Hello, class. My name is Desiree Webster. My topic is competence to waive the right to counsel and to represent oneself. A situation that required decisional competence. The competence to make a particular decision. So basically, that's what that means. Being able to make a decision for yourself, not being like incompetent, being able to know what you're doing and like this is your life you put on the line. So being able to making that decision for yourself. Introduction. Under what is known as the parents' authority, the state has historically been given extensive power to make decisions for persons unable to care for themselves. Unless the person lacks competence to make the precise decision or perform the specific act at issue, the state shall not use parents' power as justification for interfering in the person's life. The state has traditionally been accorded wide-ranging power to make decisions for those unable to care for themselves under what is known as the parents' At the same time, since the mid-19th century, much of Western society have subscribed to the principle that human dignity demands respect for individual autonomy, unless compelling reasons to infringe upon the autonomy exist. On this assumption, the state should not invoke its parent power or justification for interviewing in a person's life unless, at the minimum, the individual lacks capacity to make the specific decision or to perform the specific act at the issue. Thus, decisional competence is important and is often neglected. Okay, case study, Godinez versus Morin. On August 2nd, Tom Moore entered the Rare Pro Saloon in Carson City, Nevada, and used the automatic weapon to shoot the bartender and a customer four times each. He then went behind the counter and removed the cash register. 9 days later, Moore arrived at his ex-wife's apartment and began shooting, hitting her with 5 of his 7 shots. He then shot himself in the stomach and tried to slit his own wrist, but he didn't succeed. On August 13th, Moore summoned police to the hospital and confessed to the killings. After Moore was appointed counsel, he had pled not guilty to 3 counts of first-degree murder. Although both psychiatrists believed that Moore was very depressed, with one noting that his considerable remorse and guilt might incline him to exert less effort towards his own defense, the trial court agreed with their ultimate conclusions and found Moore incompetent to proceed. 2 months following the mental health assessment, Moore wanted to fire his legal counsel and admit guilt. When the court questioned him about why he altered his plea from not guilty to guilty, Moore stated that he wanted to represent himself because he resisted any attempts to establish a defense. Discharging his lawyers was done to stop the introduction of any mitigating evidence during the sentencing phase of the case. When he appeared before the court trial again, that's when he wished to discharge his attorneys and change his plea. His purpose specifically was to prevent the presentation of any mitigating evidence on his behalf at the sentencing phase of the proceeding. The trial judge asked Moore, was he under any influence of drugs, or was his decisions based on him being under the influence of anything? Moore replied, just what they give me, so what he was prescribed, his prescription. The trial judge did not question Moore further regarding the type of dosage or the effect of the medications to which he referred to that what was prescribed. The court informed Moore that he had the option of hiring a lawyer or represent himself. They also questioned him about his grasp and awareness of his rights and warned him against the risks and drawbacks of self-representation. So they warned him to make sure he understood what he was requesting and making sure he knew that he could hire a lawyer. I don't know why I keep saying liar. Moore claimed that he was aware of his consequences of giving up his constitutional rights, that he was aware of his accusations made against him, and he was guilty of those accusations. The prosecution wanted to give Moore the death penalty. The judge asked Moore, did he kill his ex-wife deliberately, with malice forethought? Moore first replied, I don't know. I mean, no, he first replied, no, I didn't do it. I mean, I wasn't looking to kill her, but she ended up dead. Then he replied after he asked again, I don't know what you mean by deliberately. I mean, pulled the trigger on purpose, but I didn't plan on doing it. You know what I mean? So then the judge asked again, and then he replied with yes. And then he tried to describe like his mental state at the time of like everything going down. He was like, I guess I really didn't care about anything. I wasn't very concerned about anything. It just, he did what he did, and at that point, like, instead of keep lying, he just, I guess, wanted to describe how he was feeling at that time, to make the situation better. I guess that's what he was going for. Moore was determined to be competent to enter a guilty plea and forgo his rights to counsel. He acted as his own counsel at his sentencing hearing, which was held shortly after the hearing mentioned above, when the judge asked him, did he kill her? And he did not present any evidence from being sentenced for the saloon killings. He was given the death penalty, and for the murder of his ex-wife, I put wife, I meant ex-wife, he was sentenced to life. The choice to forgo trial counsel is the one that is most likely to negatively impact a defendant's ability to attain a fair trial. This choice will almost never be in the best interest of the defendant because it deprives him or her of a skilled attorney. Further, the court recognized that even though a defendant's decision to represent themselves in court may eventually work against him or her, the idea of free choice is still worthy of constitutional protection. A defendant is not considered incompetent to renounce the right to counsel simply because he or she might not be able to comprehend complex legal concepts like hearsay rules or jury selection procedures. The decision that is so with this decision being like most detrimental to like your life, they still give you the right to choose it. And you can still get like a legally trained advocate. The level of competence necessary to waive the right to counsel was greater, according to court decisions, than what was necessary to proceed with a trial or enter a guilty plea with the assistance of counsel. The competence necessary for a defendant who wants to waive his right to counsel, according to the majority, is the capacity to waive the right, rather than the competence to represent oneself. I'm so sorry. The trial court is authorized to appoint standby counsel. If a person does waive counsel, it goes to trial. Most of my information I got from the psychological evaluation of the courts, and then the other source that I used was the competence to waive right to counsel, was just to get the definition to see exactly what the right to waive the counsel meant.